Just got back from the NAR conference in Long Beach. And it was wonderful to kind of hear from everybody across the state and see what's going on in different markets. Hear obviously the latest that of the changes that are coming, et cetera, et cetera. And there are a few changes coming to the forms, specifically the purchase agreement, which I think is going to be a big deal, not big deal, but helpful, that the SPBB will be attached as part of the purchase agreement. So we've actually had some instances where people have forgotten to either attach it or haven't filled it out properly, et cetera. And that's just really caused some confusion. And so I think it will be helpful to have that rather than have a separate form, have that actually be included in the purchase agreement. So we'll talk about how those come together as we go through the listing agreement. But I think that a number of the changes, and we've talked about this before in previous classes, where things are going to get tweaked as we see how things work and how the forms work together, making them work a little bit better. And by the way, if you have suggestions or have come across things that you feel need to be addressed differently or changed in the way that the forms work, you can always send that to forms@car.org. So I think we're mostly getting in here. So let me just go through a real quick disclaimer, and that is that the following presentation is provided by I can talk. The following presentation is provided to North County San Diego Association of Realtors members and other real estate professionals for informational purposes only, and not as legal advice or to define the real estate profession's standard of care. The instructor's views are their own and do not represent the association's position. For advice regarding specific questions, please contact the appropriate professional. And let me know if you have any questions while we're going through here. If you could put those in the either the chat or the question. Chat tends to be a little bit easier for other people to follow. If you put them in the question section, it's not like I have a staff, so I don't have people reading that and then coming at me. So if you want to have a question answered and really have it be more of something that everybody can see, put it in the Q&A. If it's something that you don't necessarily want to be addressed or have other people see, you can put that in the Q&A. Or you can just address me specifically in the chat, and that will only go to me if you put just my name in the top. So whichever way you are comfortable with, we're good with that. And I just kind of wanted to go over a little bit of the general before we get into the form, and that is the discussions that we've had up at CAR, et cetera. And that is the question of grace. A lot of us have done a lot of this, which is very admirable. And you come here and you want to improve your knowledge base, and you are all professionals and you want to do the best job that you can. Some people have not had as much training as others, and it does get a little dicey out there as we make this transition to new forms and new directions. And it's easy to ascribe a different type of a motive to somebody else's behavior, when in fact it may be simply that they didn't have that training or they didn't understand specifics. And so, sometimes taking a step back helps. And, remember the goal is to have a closed transaction where both sides are paid and happy. And then, of course, then the agents will also benefit from that closure as well. You want to be careful that you are representing your clients' fiduciary interests to the best of your ability, but also remaining professional. And it gets tougher when it gets hotter in the market or crazy in the market, and when things change and people are unsure. So just take a half a step and understand we're all sort of in this together. The board is an amazing resource. You can call and ask for information as well as CAR. The CAR Legal Hotline is a fantastic resource. If you haven't utilized it, I very strongly suggest that you do. It's helpful to have somebody who knows what they're talking about and who knows what they're talking about from a real estate standpoint. We all have, Uncle Bob, Aunt Mary, who are telling us that back in their day, they did it this way or that way. And the truth of the matter is things have changed, and the world and the industry has changed with it. And so we want to make sure that we have the most up-to-date information moving forward. That being said, let's get started on the listing agreement. So the thing that's changed the most about the listing agreement is obviously the sharing of compensation. So let me pull that up. Why is this not sharing? Hang on just 1 second. There we go. Can you guys see that? Somebody just send a rate. Yeah, perfect. Okay. So on the bundle of the listing agreement, you're going to start with agency relationships. And this is always going to be, hang on, my computer's frozen. So such always a good way to start with the 1 second here while I fix my computer. There we go. Well, let's try this again. There we go. Now I can move it. There we go. All right. So we're going to start always with the disclosure regarding real estate agency relationships. This has not changed, but I do want you to pay a little bit of attention to this, which is it explains, a lot of us have gotten used to kind of using this form, having people sign it. We never discuss it. We never go over it with them. That's something you kind of should do as part of not only your job as a realtor, but now in particular, because it clarifies your duties as opposed to the buyer's agent's duties. And now that those are so much more clearly defined, specifically in the BRBC, and the fact that you have a specific amount that you are going to begin negotiating for yourself, you want to be careful to clearly define what it is that you're going to be doing. So this clarifies what the seller's agent's duties are, and you can go through these as part of your explanation of their expectations that they are going to have of you. And they clarify what the seller's agent does and what the buyer's agent does. And an agent representing both buyer and seller is going to occur in terms of a company. So you want to clarify that as well. Mr. Seller, I work for XYZ company, but another agent in my company may also show this property. Technically, that means that the company has dual agency. It doesn't necessarily mean that you are not going to have your own individual representation through me, but that's what that means. You want to talk about the seller and the buyer responsibilities, which is, again, something that we haven't necessarily gone over too clearly, I think, in the past. And that identifies what the seller is supposed to do, and then also in the buyer's forms what the buyer is supposed to do. So this goes through the civil code, which has to do with those responsibilities. I really strongly recommend that you read this, guys, because we should be seeing the agency disclosure, real estate agency disclosure. Can you tell me if you're not seeing that? Okay, so let me try this again. Yeah, I don't know why. It's weird that all right, let's go to this again. Okay, can you see it now? Oh, there we go. I don't know why it was frozen. I will tell you that I swear the heat has something to do with how computers work. So what you're going to do is you're going to clarify with your seller and with your seller what your responsibilities are and what the buyer's agent responsibilities are, that you can represent both sides without necessarily having the same agent on both sides, and that they also have responsibilities. So then the next page is the one that again explains what the civil code is. I recommend that you read this and not necessarily read through this crazy tiny type with your client, but be able to answer a question should they have one, and to overall go over what that tiny type says. The form is only showing 3A. Are we supposed to see the entire form? What do you mean 3A? It's stuck on that page of the RLA. Okay. There's something really strange about the way this is working. All right. Let me just go back. And see why it's freezing. It shouldn't be. Okay. Now, can you tell me if you see? Okay. Thank goodness. I don't know what was wrong with this. It was frozen in some weird loop. Okay. So this is now the second page of the AD shows the civil code. This is what I suggest that you read and familiarize yourself with so that you can answer should your clients have questions. And I want to make sure that you guys understand what this is talking about. It has things in here like what the listing price is described as, what the definition of that is. It has things like what vacant land is, a recreational vehicle. It clarifies a lot of very kind of minutia specifics, not necessarily something you want to talk over with every single one of your clients, but you want to be able to understand it should they have a question. It's something that will probably put you to sleep, but you will be glad you read it should somebody ask you that question. And like, what does this mean? What does that mean? And again, it clarifies how to sign, for example, It clarifies the payment of compensation of the obligation to pay compensation to an agent by the seller or the buyer is not necessarily determinative of a particularly agency relationship. So that goes to in the listing agreement where it clarifies what you're going to clarify in this listing, right? So what the amounts are that you have agreed to accept, what the agent, what the seller has agreed to potentially pay should you also represent the other side or potentially do partial paperwork for the other side. There's a bunch of specifics here that can be clarified. This top part, very simple. The name talks about your company. So XYZ company. And the street, the city, parcel number is going to go here, all the things that are the same, obviously, in this section. Then you have the listing period. So I want you to be careful on this one because it clarifies beginning on such a date and ending on such and such a date, not to exceed 24 months if improved with 1 to 4 units and not owned by an entity. If the listing period exceeds 24 months, this agreement is void unless Sellers Corporation, LLC, or partnership. You want to make sure that you adhere to that timeline. If you want to extend, we'll go over that as well. There's a form. There's a form for that. It used to be there's an app for that. Well, now there's a form for that. So the property specific listings, if you have a manufactured home or a probate, it is no longer a separate form. You simply check the box and it will attach the additional form that you need. One of many billion times it says it in this contract. Compensation or the amount or rate of real estate commissions is not fixed by law. They are set by each broker individually and may be negotiable between seller and broker. So there is a broker compensation advisory that is going away, by the way. So in December, when the new forms come out, there will be slight tweaks. The majority of this will stay the same, however. So the compensation to the seller's broker is only your side of the compensation. And again, back to that AD, you're talking about what it is that you do, how you represent them, what your fiduciary responsibilities are, all the billion things you're going to do. You're going to, hold open houses. You're not going to hold open houses. You're going to, work with your stager. You are or you aren't going to work with whatever it is that you do, your advertising, et cetera, et cetera, et cetera. You talk about all of that stuff. For that, here's the percentage that I charge, or here's the amount that I charge, or I do a percentage and an amount for maybe a TC or for that stager or whatever it is that you charge in addition to, or if there's a flat fee or whatever your attached compensation schedule. And I've had a lot of questions about that one. What does that mean, attached compensation schedule? That is, there have been a number of instances where if it sells for this price, then I, Mr. Seller, am prepared to pay you this amount. If it sells for this price, I'm prepared to pay you this amount. Or if this person, closes in 30 days, it's going to be this. If it closes less than that, it's going to be that. Whatever those changes are to that contract, or if anything is changeable about that contract, you would write that on a separate page or a addendum to this contract and attach it. And that would be the compensation schedule specific to how you are paid, not like timelines or if it includes the car in the garage. Additional compensation to seller's broker if the buyer is unrepresented. That's where I mentioned that if you have an unrepresented buyer that comes into an open house, for example, and does not want to be represented, but still wants to purchase that property and your seller is fine with that, if that should happen, then you understand as the seller's representative that you are going to be bound to protect your seller's interest. And that will likely involve you doing extra work to cover that buyer who is not represented. Does not mean you will represent them. It means that should that be an occurrence that you have agreed in advance that you will be compensated for that additional work and or paperwork. That is an extremely negotiable number, both with your broker and with the seller. Some brokers are saying they don't want that. Some do. Some set an amount that they don't want to go below. All of that is something you will have to discuss both with your broker and with your seller. The continuation of the right to compensation for broker identified properties. So this is the same basic idea that's always been in the contract. If this listing is expiring and I've shown it to 5 buyers before the end of this listing agreement, I am going to give you a list of those buyers within X amount of days. And if they buy it within, and this is where you're going to put the timeline, 90 days, 120 days, whatever it is, 90 calendar days for after the listing period, and they close, that's the continuation period. So is there any obligation owed to a previous broker? Again, referencing basically this same information. Has a previous broker who had this listing registered any buyers with you for which compensation is owed should they purchase the property? Or do you still have a listing with another broker? Hopefully that's not the case, but we've all seen it happen. And the other broker, if owed compensation, if the property is transferred to, and that's where those names are going to go, or generally, depending on how long that list is, maybe an attached list. Then you get into the specifics of that property. What's included? This is where all of us from day one in real estate have always known that you want to make sure if you've got grandma's chandelier that is removed, preferably from the house before it gets shown, or if it's excluded, that you very clearly identify it as not going with the property. There have been a number of instances where, you know, a house is gorgeous because of the way it's decorated or because of those additional touches that then get taken out of the property when people move. That can be an area of disagreement. And so you want to be clear and in writing what is and is not included in that transaction. And again, really strongly suggest if something is not included that it not remain for showings, unless it's really going to destroy the character of the house. But if, for example, that chandelier doesn't go, I would really recommend that somebody just trade it out before it even gets shown. Unless it's, you know, from a chateau in France or something and you can't move it. I'm not sure what the situation is in every case, but either way, be very clear that is included or excluded if it's included or excluded. So again, you want to make sure that all of the items that you're going to go with that property are written up here, and the ones that are excluded are here. Leased items, propane tanks, solar water systems, water softeners, alarm system or solar power systems or alarm systems. All of those things, if they're owned by somebody other than the owner of that property, you want to make sure that you have the information on it, the contract for it, the length of time that it is in, that it has left on the lease, and the contract if possible. Liened items, heating, ventilation. So we've all seen all those systems where there's a lien against the property and it has to be cleared, and sometimes that causes a problem. So that's both an item that you want to have the information on, and you want to make sure that your title company checks into the actual amounts that are due on those and what has a lien against the property or not. Some people think there's a lien and there isn't. Some people don't think there is and there is a lien. So you want to make sure you check that. I actually had a property listed at one point where the guy owned a cabinet shop, and he closed the cabinet shop and his previous employees hadn't been paid. And when we checked into the title on his property, they had all, I think 3 of them filed liens against him for back pay. And it was quite the shock to him when it came to it. So I want to make sure that you guys are being very careful about these types of things. We're seeing more and more of it show up. And always make sure you check and have that discussion with your sellers. Smart home features, the seller prefers to include or exclude. This was a bigger deal when this stuff first came out and everybody was sort of hoarding their, cameras and things like that. It's not as big a deal now. There's, you can get Wise cameras for $30, so it's not a big, freak out when those are excluded. But again, this is something you want to discuss with them, make sure that they are very clear and you have in writing what's included or excluded. Property will be marketed in the following MLSs, primary and others. If you guys have a secondary MLS, which in San Diego is pretty common because there's 2 MLSs, and if you work in Riverside or in the desert, that goes up to 5. You want to make sure that you include those as well, because some of those MLSs have different rules. And as we move into this changing of rules and the NAR settlement, which by the way has not yet been filed, it has not been settled. You want to make sure that you are clear on what the rules are for each one of those MLSs that you belong to or first or secondary members of. There's a lot of data sharing. And for example, I've had people ask to have photos taken down after close, which not only is not possible because the MLS owns those, but secondarily, if it's been extended to several MLSs, and those MLSs have data feeds, we literally, it's like nailing Jello to a tree, trying to track all that down and put the toothpaste back in the tube, and all of those sayings kind of apply. So here's an interesting one too, and this one's coming up more and more often as well. Seller instructs broker not to take or use photographs in marketing, except as required by MLS rules. How many people know what that MLS rule is if you have a listing in the MLS? Exterior photo, right? Okay, so if you have an exterior photo and that's all your seller wants, first of all, it's going to be difficult to market that property. But secondarily, this has to be checked, and you have to have had that discussion with them about how that's going to hamper their ability to sell their property. Timing of presentation of offers. So again, what most agents don't realize is even if you have an accepted offer, you are required, unless written notice is given to you not to present all offers up until close. So even if somebody brings you an offer the day before close, which I literally have never seen in 30 something years, but could happen, you are required to present it, or you can have your seller explain they want offers presented on such and such a date, or X dates after the property is listed as active on the MLS, which would then stop the requirement of presenting all those offers. Okay. So you want to make sure, again, you have that conversation with them. So present all offers received as soon as practicable. That is up until literally close, or have them by a certain date or some variation thereof. You can say, yeah, bring me everything until this date. Bring me everything until contingencies are removed. You can have whatever you want as that delineation, but make sure, again, it's understood that that's what your seller would like to do. The buyer supplementation offer letters. Again, this is one that hasn't been as big a deal as it was when it first came out. But again, you want to make sure that you explain to your seller why we don't recommend the pretty little buyer letters. And all of us, I'm sure, have either used or suggested to our clients in the past that they do this, but it runs afoul of the fair housing requirements, because it allows people maybe inadvertently to make decisions based on something other than the fiduciary ability of the buyer to buy. So you want to make sure that they don't put themselves in harm's way or expose themselves to liability by accepting letters. And if they do, they're acting against broker's advice. And if you do, you want to check this box if they do want to receive those letters, and it says it's the seller is acting against broker's advice. Investigation reports, and this is the broker and owner's duties, right? So these investigative reports, broker's obviously going to order them, and the seller will pay for them. Shall order and pay for reports within 5 days of the beginning date of this agreement. So structural pest control has been one that has been very common. General property inspection, that's generally a buyer, although if you're in Northern California, that has been a seller responsibility. So again, it's wherever is common in your area. The homeowners association documents, that's generally going to be a seller. But again, in some areas, that has been buyer, and it depends on what the market's doing. So that's why these are not automatically checked. The only one that is the natural hazard, because that's required by statute. Roof inspections, pool inspections, sewer and septic inspections, all of that kind of stuff depends on the market and the area, and whether it's a buyer or a seller market as to whether one side or the other pays for those. You know what's standard in your community. However, I would have that discussion with my seller. Exceptions to ownership and title. This is one that's kind of interesting because we've had a number recently of properties that have been, the death of a parent or a spouse, properties that are held in trust with several members of that trust, et cetera. And so you want to be very clear about the ownership and have that discussion with your title rep to make sure that there are no exceptions to ownership or title. The seller intends to include a contingency to purchase a replacement property as part of a transaction. So the SPRP will automatically attach itself if you check this box. Seller opt-outs, if they don't want a key safe or lockbox and they don't want signs, or they can't have signs. In some cases, there are some communities that do not allow signs outside. They only allow signs, for example, in the, upstairs bedroom window in a certain size and a certain color. In Rancho Santa Fe, you have to have green. There's just all kinds of areas where they have funky little rules and requirements. So if your seller has any specifics about that, the key safe lockbox, again, there's a whole form on that and explains why that's helpful, why that's necessary. If they don't want that, you're going to check that and it's going to add that to that transaction. H, is that in regard to 1031 exchange? It could be actually anything. Yes, that could be a 1031 exchange. It could just be they want to identify and purchase replacement property as part of the transaction. Either case, we have a lot of people who are downsizing and they want to find the other house first. It has been a little difficult recently to find other properties. And so that's been more common of a requirement. But yeah, it can also include 1031 exchanges. Advisories and addenda, the broker compensation advisory BCA is included automatically. Again, that is going to go away because it's going to be part of the bulk of the form itself. If it's an REO, you're going to have those things you can add. If you have a trust, and use that form, you check that box up above that says it was a trust, you're going to add this. If it's a short sale, et cetera, et cetera. Any addenda. So if, for example, it's going to include all of the furniture in the downstairs, you're going to add that. You're going to have a list of what's included or not included. Don't recommend including furniture. Just the only thing I think of in the top of my head because I only had 1 cup of coffee this morning. Compensation to broker. That's one that's fun because I'm still training my brain to say compensation and not commission, but the amount of real estate commissions is not fixed by law. Again, one of the million places it says this. It has actually always said this, but we are all hyper aware now because of the lawsuit. They are set by each broker individually and may be negotiable between the seller and the broker. So you're going to make sure that you include any discussions that you've had with your seller, that you include either an email or something that represents it. That you have that clarity in your files as well. Additional optional compensation for represented buyer. That's the one I mentioned above. Compensation terms, completed transaction or seller default. That's one of the things that has actually come up. Like if the transaction doesn't close, is the agent still entitled to commission if they found a ready, willing, and able buyer? Yes and no. If the buyer cancels with an outstanding, they didn't get their loan, they didn't approve of the property, anything like that, then there's nothing owed. If the transaction cancels because the seller woke up on a Tuesday and thought the sky was the wrong color, You might have something to go back on them for if they just flat out change their mind. Sure. Do we see that very often? Not really, because we don't really want to be known as people who sue people for, pay me a commission, although I didn't sell your house. But technically, yes. And I think it would depend on how egregious that level of change of mind was. If you had, come all the way down to the finish line and, worked your butt off for 6 months and, staged it and all those kinds of things. But if that actually were the case, I would recommend to you guys that you have a discussion with your broker about how to protect yourselves from the expenses of that in any case. But yes, that you, again, that's it's an interchangeable potential. The seller interference with the listing. We've had this happen where a child of a seller has tried to talk a buyer out of buying it because they wanted to have it be less expensive for them to buy. There's all kinds of fun things that happen with real estate. So it's a large investment, and with things that are worth a lot of money, people sometimes lose their minds. So the buyer breach and seller recovery damages. So and this is kind of one of those weird ones where the seller sues the buyer for breach, and then are you entitled? Well, again, it talks about that. If and when the seller collects damages by suit, arbitration, settlement, or otherwise, and then in an amount equal to the lesser of 1/2 of the damages recovered or the compensation you would have been due. So again, depending on the nature of that transaction and what actually happened, that's up to each individual broker and agent to decide. But it does have compensation protected in the contract itself. I really have not seen that be an issue. Most sellers, when something like that happens, are happy to work with the agent. Most of the time, the agent is working with them to help them recover money anyway. So it just, it's an individual situation, but you need to have a discussion with your broker. Seller compensation obligations to other brokers. Seller represents the seller has not previously entered into a listing agreement with other brokers, doesn't owe anybody. They don't owe anything to anybody. There were no previous agreements. The maximum listing period I mentioned is 24 months. If you try to go above that, it'll void it. You can do extensions after the fact. I mean, you can extend for a lot of things, price changes. There's a lot of things that can change that you would want to do a modification of terms with anyway. And that's something that is giving the seller flexibility as well. You want to be really careful again with the leased and not owned items and the seller representation. If the seller tells you, oh, I just had the roof replaced. We've had that happen a number of times. Somebody says, I just had the roof replaced. Well, he had it replaced 10 years ago, but he's thinking it's just. In real estate, that's not really just replaced, right? So you want to be very clear and very careful to represent what the seller actually has done. So, okay, Mr. Seller, it's great. Your roof does look good. Do you have any of the receipts from when that was replaced? And just get the copies, put it in writing. Again, when it's in writing, it clarifies it for everybody. And there are far fewer misunderstandings when you have the receipt that says when it was done and the dates on it and the person who did the work. The broker responsibility, authority, and limitations, it clarifies it. Again, if you go over this with your seller line by line and explain this to them, it gives them a really good idea of what you are responsible for, your broker is responsible for, and what they are responsible for. And it helps. I always say good fences make good neighbors, right? And the reason that is because it clearly defines the area that you're responsible for. And that's what this does. These are the fences. So you want to make sure you clarify with your seller what they're responsible for, what you're responsible for. And the seller instructs the broker to present offers when, and again, that form up above clarified if he wants them right away or only by a certain date. You want to make sure that you go over this section again about the letters and why it's important for them and what they're putting themselves in danger of if they accept those letters. And then the seller good faith, he is acting in good faith. And that is good faith and fair dealing is the number one requirement of a contract, right? So if the seller is acting in good faith, you're acting in good faith, the buyer is acting in good faith, everybody's happy, we close the deal, we're done, right? That's the requirements. That's what we want to have happen. Undisclosed conditions, incomplete or incorrect information. Again, that goes back to the 10-year-old roof that I mentioned. I don't think it's most of the time intentional. It's just people's memory of things is sometimes different than what actually happened. I do that all the time with my kids. Like, oh yeah, remember, a couple of years ago? And like, Mom, that was, 5 years ago. So that is something that's just sort of a human failing. So take the time to make sure you don't do that and make sure that you have the clarification of information that they've given you and the information you're going to be passing on to a buyer. I've had this happen again where an agent was told something by a seller and relayed that information to a buyer, and it was incorrect. And it's gone from things like this view is protected, the septic is over here, the septic was, new 5 years ago. All of those things can be verified and should be verified in writing before you give them to a potential buyer. Once you pass that information on without a disclaimer or without backup of that information, it becomes your information. So you want to make sure that you have that information clarified. And you make sure, so this clarifies that the seller agrees to indemnify and defend and the hold broker harmless from all claims, disputes, litigation, judgments, and cost. But I will tell you, I've been to a dozen hearings where this is not the case. And they said, oh, I thought that was true. And the agent did not verify. And I will tell you that agents not verifying is going to hang you by your own petard. So don't do it. Disclosure, you're going to, the AD form that we went through above, the seller representation that the broker shall represent seller in any resulting transaction, except as specified in paragraph 4F3, which was previous buyers who they had registered, that they've given you notice of, that were that come back within the time frame that is noted above. If that happens, you are under no obligation to represent the seller in that transaction. Disclosure and consent in a transaction. Is that not there? Depending on the circumstances, it may be necessary or appropriate for the broker to act as an agent for both seller and buyer. So that's when you have, Fred Schmertz from your company and you both representing both a buyer and a seller in the same transaction. Technically, they are agreeing to dual agency. Showing property seller acknowledges that the real estate brokers must have a written agreement in order to work with a buyer before showing properties to that buyer, and that some buyers working through a broker may consider or make an offer on seller's property. The seller consents to broker entering into a representation agreement with a buyer, and if that buyer makes an offer on the seller's property, broker will become a dual agent, represent the buyer and seller, and that's single agent dual agency. Unless you have somebody from your company holding your open house that then brings in a buyer and represents them, then it'll be just simple dual agency. So that situation is one where you want to be really clear with your seller that if somebody comes through that open house and you have them sign the ONC and you have them, they register and they say, okay, I want to write an offer on this property. I want you to be my agent. You want to have that understanding with your seller in advance of that happening. Are you good with that? Are you not good with that? Am I good with that? Am I not good with that? So again, have that conversation with them. We've had a lot of situations where while it has been explained to the seller that this, the dual agency exists, they didn't understand it would be the same person representing both sides. So you want to be very clear, if that's something you do and your broker approves, that you explain that to your seller. It just clarifies so that there is no misunderstanding. And then you have the unrepresented buyers that come in an open house. As I mentioned, if a buyer is interested in viewing the seller's property and is not already registered, represented by a real estate broker, and such buyer refuses to be represented by a broker, the seller authorized broker to obtain a signed document from such buyer refusing representation, The broker shall provide such buyers at the earliest practicable time a disclosure of non-representation, such as a buyer non-agency or open house visitor non-agency, the ONAC. So either of those two forms are sort of interchangeable for a buyer who does not want to be represented. We've had a lot of talk about when you have an open house and you have to have people sign a buyer non-agency, or you have to have them sign. You don't. If somebody refuses to sign anything and they want to come through that open house, it's an open house. You're not a bouncer at a bar. You can let them in. I would just have a conversation with them and ask them to sign saying that they don't want to be represented, because that tends to be their hot button. And if that's the case, a buyer non-agency might make them feel better. But the ONAC form, the OHNASI form, also has a clarification in the very opening of that first 4 paragraphs of that form that says you don't have to be represented. Represent yourself. You can have me represent you, or you have a buyer agent already. And they can choose whichever way they want to do that. But again, you want to clarify that with your seller and understand from their standpoint how they want that handled. Do they want people coming in their house that refuse to sign in? And do they just want to know who's there, for safety reasons, essentially? A lot of especially now with this safety focus, and it's rightfully so. There was another death recently in, I think, Colorado, of a real estate agent. So we want to make sure everybody is careful. And we always recommend 2 people at an open house, just because you've literally got strangers walking into a house. And that's a situation where you can have, one person make sure that people are signing in. We've also, by the way, at the CAR meetings, had discussions in the risk management forum where during open houses, other agents are coming up and just taking these forms and running off with them, or taking pictures of them with their phone and then calling all those people. So you want to be careful to protect the integrity of that open house and of the information of the people that are signing in. Maybe, have it put in a safer place. I don't know, whatever you guys want to come up with, but be aware that that is happening out there. Additionally, out there are secret buyers. They're not being put out there by CAR. They're not, as far as I know, put out by DRE. They are more than likely, and I believe they are representatives of the DOJ, to see if we are following through with paying attention to the settlement agreement. So you want to be careful that when the big clue is they'll call up and say, I want a tour. We don't generally use that terminology when we're talking about going to show an open house or just go show houses. We don't call it a tour. So that's one of the giveaways, although now that, we've known about it and are talking about it, they might change. But if somebody just calls you and insists on going to a house and says they're not going to sign something, I would be aware and be a little wary of that person, because that violates the letter of the agreement. So just be careful and understand and talk to your broker about what your potential, or what your standard operating procedure is going to be with regard to showings. And, we're getting in the habit quite a bit when somebody would want to show a house to get a copy of their driver's license. And, those are safety precautions. Well, we also want to pay attention to legal precautions as well, and make sure that we are covered when we go out with a virtual stranger to go look at properties. The confirmation termination, you guys are aware of these. Security insurance showings, audio and video. So audio and video, by the way, are things that are becoming increasingly common when you have people with all kinds of cameras throughout their houses. You have to identify that those are there, and you have to let people know that they can be recorded during this showing, during the open house, and to make sure that they are aware that that is something that is occurring. Photographs and internet advertising. That's one of the things, by the way, that has come up, where people are going to open houses and videotaping or videoing on their videotaping, showing my age, video phoning the house and posting it on their social media. And you cannot do that without the express permission of the listing agent and the property owner. That's considered advertising. And if you don't have the written agreement of either of those, that is a violation. You cannot do that. So make sure that you have the agreement, especially if, for example, this particular listing is somebody that did not want photos. And then you go in and, take pictures. So just make sure that you are aware and act accordingly. The seller acknowledges that other people and prospective buyers coming into the property may take photos, videos, or other images of the property. Seller understands the broker doesn't have the ability to control or block the taking or using of images. We can say don't do it, and they shouldn't do it, but sometimes they do. So you just want to warn them. I'm going to tell them they can't, but sometimes they do anyway. And then a key safe lockbox, again, that's if that seller checks that box that says, I don't want one. You're going to explain to him why he probably should. But if he doesn't want to, he doesn't want to. I had quite a lot of that in my early career, and a lot of our sellers wanted to have every showing accompanied by the listing agent. That's fairly common. So if you have a property that's, one of 25 condos in a community, it's probably to their benefit to have a lockbox. But again, that's going to be a discussion between you and the seller and what makes the most sense to get the most eyes on his property, who will, obviously result in more eyes and a greater likelihood of sale. The sign, he's going to say, unless it's checked in that section up above, that you're going to put a sign on the property. And then it goes through the rest of this information. One thing I did want to clarify, though, here on 16, management approval. If an associate licensee in the broker's office enters into this agreement on the broker's behalf, the broker or the manager has the right to cancel this agreement in writing within 5 days after its execution. So if you have a listing and you don't get it to your to your manager, to your whoever runs your office, to your broker, and they don't approve it within 5 days, you are technically out of contract. So you want to make sure that this is given to the appropriate parties within that timeline. You also might want to check with your E&O insurance, because if it hasn't been approved and it's required to be approved, it might have an impact on that. So again, have that discussion with your broker and your office managers to make sure that you are working within the timelines of the compliance and that everything is as it should be. I mentioned that we have a number of properties that are in trusts, or there's a decedent, and then you've got the person who's in charge of that trust, et cetera. So the agreement is binding upon the seller and seller successors and assigns. Mediation explains what that is and what the need is for it. If we end up in a mediation situation, it tells what those terms are talking about, what what arbitration is, and the difference between mediation and arbitration. And by the way, mediation is always, up until the moment that you sign an agreement, it is non-binding. Arbitration is going to be binding by a judge or sometimes a retired attorney. The entire agreement, all prior discussions, negotiations, and agreements between the party are superseded by this agreement. So if you had an agreement last year to sell somebody's house for $1.50, and then this year they say it's now $2, that supersedes the prior agreement, even if it was in writing and even if it extends past the time on this one. Ownership, title, and authority. Seller says they own the house. Legally authorized signer. It's a trust, and the person who signs it has the legal right to sign it. Entity sellers. This is how you are going to put this here. Jane Doe is the authorized signer for the Jane Doe 2 family trust, dated whatever it's dated. So the length of the ownership, the ownership is going to be what is on that title. And usually the tax rolls will reflect that. Sometimes it's, backwards and sideways, or somebody inputted it wrong, or it, came out sideways or something. But generally speaking, that name of that big name of the trust, and then there's a person who can sign for that trust, or sometimes 2 or 3 people that can sign for that trust. So this allows that person to sign. This is who owns the property, but this is who can sign for that name. So that's what you want to make sure you get clear. And then this person can just basically sign everything, and you make sure that they have their title there. It's the same with an LLC. It's the same with any entity. You want to make sure that their title is here, their name is properly identified here, and that you have the ability for that person to sign. Then you have your information, your broker signature. So the multiple listing service addendum. So again, I mentioned that some of those multiple listing services have different rules and different regulations. This clarifies what the MLS is, which MLS you belong to, what is the broker's MLS, what does it do, how does it work? We found that a lot of sellers had no idea what an MLS was. They thought we were the MLS. A lot of times people think the board is the MLS. That's a separate entity. It's a separate company. The impact of exposure of listing through the MLS, again, we were talking about eyes. That's the number of eyes on that property. The impact of opting out of the MLS. There's a lot of companies that are popping up now saying, oh, we'll just list it for you in our super secret listing format. And, it can be interesting to utilize those programs. It's up to your seller to decide which one is best for them. Again, generally speaking, the ability to sell a property is tied to how many eyes see it. Okay, so the public marketing of the property, clear cooperation property policy. This is something that has been a little bit controversial. It's actually gone back to the DOJ. It's being discussed at this point. At this very moment, it is what it is, staying the way it is. But it, like most things in real estate, can change. The clear cooperation policy requires that residential real property with 1 to 4 units and vacant lot listings are submitted to the MLS within 1 business day of any public marketing. So again, pictures, that's public marketing. Putting a picture on your social media. Look at this beautiful view in this house. It's coming. Okay. Once you do that, that's called marketing. You have to have it listed. Put a sign in the property on the lawn. That's called marketing. Once you do any of those things, you have to have a listing, and it has to be put on the MLS within 1 business day. A lot of people cheat that and put something up on a Friday and then have it listed on a Monday. You can do that, but it's, again, you want to make sure that you stay within the golden rule of acting as you would like to be treated. You don't like when your client drives around and sees an ad or a sign on a property that you can't show them. I would like us to remember that we all work together in this industry. Coming soon impact, that's a 21 days. We are all familiar with that by this point. The seller instructs the broker to market the property on such and such a date. This is when we're going to replace the carpeting, we're repainting, we're re-roofing, we're doing whatever. Don't put it on the market until this date. We're on vacation, whatever their reasoning is. You have to have that in writing. And if they instruct you not to put it on the market until a certain date, then you need the SELM or equivalent to understand that you have the right not to market. So a lot of people have asked this question, by the way, because some of the MLSs do not require a copy of that SELM. You, however, have to have one. Any agreement between a seller and an agent must be clear and in writing. So whether you have to provide that information to the MLS in order to put it on SELM or withdrawn or whatever the status is that you're trying to hold it in, you have to have in writing the agreement with your seller to do that, no matter what it is. So if you have an agreement with them to not put it on the market or to put it on the market as a coming soon, again, that's in writing. If you have an agreement to not put it on the market, that needs to be in writing as well. The clear cooperation policy does not apply if the MLS utilized by the broker did not have a clear cooperation policy. I don't know of one in 150 or 200 miles of San Diego that does not have a clear cooperation policy, but if you do, that wouldn't apply. The MLS data on the internet, you can opt out of that. So if you have a seller that has the concern, and we've had some, famous people, incredibly wealthy people, people whose ex-husbands are, trying to find them or whatever, don't want photos published. You can opt out of the IDX feed that would give that photo out there to the, that you can't then take back down after the fact. So if that's a concern, make sure you have that discussion with your seller and clarify to take those things off of the MLS, or not on the MLS. Don't publish the pictures and don't secondarily publish those photos. And the SELI is that form, by the way, so that you can have them opt out of the secondary feature. Comments and reviews, the ability to write comments or reviews about the property in those sites, or the ability to link another site, is an immediate conjunction with the property display. So you want to make sure that you have the clarity with your seller as to where this is going to go and how many websites. So when you talk about people who search online for properties, they are searching the MLS. It's just a version that they've gotten as an IDX feed. And that is something that is very specifically tied to the MLS. But then once it goes out of the MLS, they don't have control over it. So you want to make sure you have that understanding with your sellers as well. You're going to have them sign the SELI if they want to opt out of those certain features. Concessions and explanations. This is the one that most people have the issue with. Concessions are monetary payments that a seller agrees to contribute toward a buyer expenses and other costs a buyer is responsible for in the transaction. Concessions may include, but are not limited to, the cost of escrow or title, lender fees, repairs, inspections, and buyer broker compensation. A lot of people panic with the buyer representation section of that discussion with regard to concessions. Those fees have always been paid by the buyer, put into the loan, paid through the seller, and then it is gone to the other side. In this case, it's gone to the broker. That is no longer the case. It doesn't go broker to broker. Now it will go directly from the seller to the broker, but it's still the same circle. It's still paid by the buyer, which goes into the loan, which goes to the seller, which then goes to the other side. So I want really to look at this as the same buckets, just different names for how they are dispensed. And no longer in the MLS does it say what that percentage is, because it's negotiable. It has always been negotiable. We just haven't emphasized it. In the MLS, that concession is a flat fee. It does not clarify. It can be a percentage. It can be a number, but it will not delineate between roof, lender fees, the buy down of a loan, or buyer broker compensation. If your seller is willing to cooperate with the buyer and pay for new flooring, you've always been able to negotiate that in the contract. This is the same concept. It's just lumped together now, where all of those fees are just called concessions, right? Some of the MLSs, not all, but some of the MLSs now have, when that deal closes, a delineation of what those fees were after the fact. It cannot be done during the offering period. You cannot be in the MLS as an active listing with the numbers delineated for, $10,000 for flooring and, $5 for the roof and X for compensation, it will be able to be delineated in the closed file. That helps appraisers, it helps agents when we're looking at comps, and it helps everybody to understand what the actual price of that property was. I strongly encourage you guys to talk to your brokers about how to represent that once a deal has closed. And so you want to make sure that that is something that you have that discussion with your seller with. Can you discuss what happens when the concessions exceed the lender amount, allowed amount? The lenders have clarified, because we're all aware of that 3% that lenders allow for the buyer concessions. They do not count the broker compensation in that number. So the amount of broker compensation, should a seller agree to pay or to allow that to kind of pass through their percentage rather than have the buyer pay it directly, that is not counted in the lender fees. And even the VA has agreed to that as well, which was really one of the main concerns a lot of us had, because they have always been strictly opposed to any kind of compensation in that regard. And they've agreed because they understand that that would effectively, cause a big problem for VA buyers. It is all lumped together in one amount in the offering. It cannot be delineated when a property is on the market. Once it goes into escrow, and then you work with your lender and you explain what the amounts are for, that's when, and we're all actually very comfortable with that discussion with the lender. How do you want me to describe this fee? Closing costs, recurring and non-recurring closing costs. How many times have we all heard that terminology, right? So the same is true here. They just want to know what the percentages are that go to what when you're in an escrow. It's up until that point that cannot be identified in the MLS, and it cannot be shown in the MLS until closing. And then in that case, it's utilized for comps, so that you can do a comparable market analysis with actual numbers. If everything is just thrown into the same number, you don't know if they had a bad roof or if there was, all of that amount was used for a giant hole in the living room, or, you know what I mean? You have to have some sort of clarity as to what those fees were or what that amount was. But yes, the lenders are aware that that is a new way to do this transaction. And so they're prepared to underscore what that amount is, and specify for broker compensation versus title lender fees, repairs, etc. The seller authorization, the seller does not authorize the broker to put in the MLS that the seller is willing to consider offers asking for concessions, or B2, the seller authorizes the broker. So you want to make sure that you understand this section right here and that your seller understands this. 5B, 1 or 2. And again, you want to have this very clear understanding so that you can explain it to your seller. And this section, this whole form is actually a very good way to kind of walk through this with them and explain how this works. And it's no different than, green shag carpeting is going to interfere with your ability to sell your house. So you're going to offer compensation for the buyer to put in the kind of shag carpeting that he wants, right? Or he's going to put in laminate or whatever he's going to put in. So this is a sales aid for your seller, and also clarification for you. It's part of the negotiation. A lot of times people will put stuff in the MLS, the outdoor refrigerator, you still have to write that in the contract. And that's exactly where we are here. Even though things are, you're saying you're willing to negotiate or you're willing to consider compensation. So write it in a contract. A lot of agents are having a hard time kind of overcoming that past a pre-shared agreement. But I want you to think of it a different way. In the old days, in the before times, somebody else negotiated what you were going to be paid. Now you get to negotiate that. Now it's in your bailiwick, right? It's in your power to negotiate what you're going to agree to accept on this transaction. And it is now up to your buyer and your seller and you with your buyer, and then your buyer through you with the seller to negotiate what that final number is going to be. So again, it's less a loss of information and more a gain of control. Visitors are restricted from taking photographs, or you can put in the MLS. Visitors are not restricted from taking photographs, or you're going to put in the MLS that they can only take pictures for appraisals or inspections. It depends on what your seller wants. And again, you want to have that conversation with them. So this is a standard seller's advisory. But again, especially in this timeline with the new forms, I want to make sure that you guys are aware that this is going to be helpful for you. We've gotten so used to sending things to people to just sign with a digital signature platform. And you want to make sure that you have this conversation with them, read it through yourself, understand it yourself, and then walk them through it step by step so that they understand what these things all mean. Pre-sale inspections and considerations is generally a Northern California thing. That has been a very big Northern California, probably for 10 years now, where they do all their inspections ahead of time. We do more of the post-sale protections. And then again, safety and precautions, holding open houses, et cetera. It talks about what those safety precautions are. And you, not the broker, are responsible for the fees and costs to comply with your duties and obligations to the buyer of your property. It is not up to your agent to fix your drywall. Broker compensation advisory. Again, we are going to beat this to death for a very long time. Right now, this form is still in existence, so you need to use it. And this clarifies, and actually this will probably be here for a bit, what that compensation is. It's fully negotiable. It is optional to compensate your listing agent if the buyer is unrepresented. Buyer may represent both buyer and seller, and that's called dual agency. And the buyer representation is fully negotiable. Again, the requirements for written agreements, I mentioned that earlier. This is really important. Everything that you agree to with a buyer or a seller must be in writing. It must be signed and agreed to in writing in order for it to become part of the contract. If you have a verbal agreement with somebody about something, immediately get it in writing and get signatures on it, because otherwise it will not hold up. We always have amnesia in lawsuits, guys, and I've seen a lot of it. Nobody ever remembers telling anybody anything. And if you don't have it in writing, it doesn't exist. Advantages of written agreements. If it's not in writing, it doesn't exist. That's a pretty big advantage. Clear mutual expectations and avoids misunderstanding. That's that fences make good neighbors thing. Clear understanding. The buyer pays the compensation pursuant to a buyer representation agreement, unless he gets the seller to agree to include it in the purchase price, which then includes it in the loan. Most buyers are going to be in that camp, simply because if they're trying to buy a house in today's age, they have to give you their firstborn child right now anyway. And, coming up with the additional compensation is going to make buyers even more scarce. Luckily, prices have gone down. Interest rates have gone down a little bit. So hopefully that's released some of the pressure. The seller pays the compensation. And if they do, how that works. So they negotiate for the seller to pay the buyer's broker. The buyer agent negotiates an agreement directly with the seller. Either one of those things are how this can occur. Generally speaking, it's going to be that the buyer through you negotiates for the seller to compensate the buyer's broker. The changing practice, historically in California, we've used an MLS to make a unilateral offer of compensation. That no longer exists. Now it's the agreement with the buyer representation agreement. And this is how we are going to have this negotiation happen, Mr. Seller, when we get an offer. This is the one we're all familiar with, which is the possible representation of more than one buyer or seller. Fair housing, this is the one where you're going to discuss with them about the love letters and why they should not utilize love letters to help make their decision. Although it's tempting to look at the lovely photos of the family with the kids and the dog, that could expose them to potential liability. The California Consumer Privacy Act, this again, if they don't want to have their photos in place, modification of terms. If you have a listing, I mentioned 24 months is the longest amount of time that you can have. If you have one that's changing, either extending, changing price, whatever it is, compensation maybe, any of those things you can, and the compensation is down here. You can use this form, which is the MTLA, and that's specifically for a listing agreement. Disclosure and modification to listing agreement. So this is in the very beginning. So you're going to say the modification of the listing agreement, since the broker agrees to notify seller once the MLS will no longer be able to use to offer compensation of buyers brokers. This is no longer really utilized because we already, that's already in place, that it no longer offers it. So this is not used. But I just wanted to bring it up because it's been in existence. If somebody uses that form, you want them to use the other one, which is the MTLA. I'm sorry. Yeah, MTLA. Okay, so then disclosure regarding real estate agents agreement relationship again will show up when you use the buyer representation agreement. That is statutorily required. Anytime you have an agreement with somebody, you have to have the buyer representation agreement attached, or the agency relationship agreement attached to a buyer BRBC. So the BRBC will only be valid for 3 months. So that's 3 months, not 90 days, 3 months. I love how some things are 90 days, some things are 3 months. And this is when you put in that date. You could be shorter. You can have it be for a month. It could be a week if you wanted. Exclusive or non-exclusive. We've gone over this a couple of times. I believe they're leaning towards potentially changing this to just be exclusive. But if they do that, I do believe that they will change it to requiring broker involvement for representation. So right now, if you have a non-exclusive agreement, you have to prove representation or broker involvement in order to have it be valid. The exclusive does not require broker involvement. In other words, you can give a list to somebody, they can go out, look at the properties on that list, and still have that be acceptable. So the question is, does the BA state concession amount separately on a blanket amount that you're not aware of the coming to letter fees? Exclusive, okay, so property type. The property type, you're going to check on here what they're going to look at. You can check more than one. This question was asked earlier, and it's automatically going to be a single family, including condos and manufactured homes. If they also want to look at multifamily and vacant land, or if they don't want to look at single family, you're going to check that box. But if they want to do single family and multi and vacant land, or just single family and vacant land, you can check more than one box, basically. The location, counties and cities. A lot of times you can use zip code. You can say this, for this, you can put in following properties only. You can put 2 or 3. If you have somebody that wants to limit you so specifically, then you might want to do the PSRA, which is we call it the dating form, which can be 3 properties and is much more limited than this. It just depends on your relationship with the buyer and what they're willing to work with. But again, you want to make sure that it's comfortable for both sides, that you guys both understand what you're agreeing to. So you're going to have a county or a city. Generally speaking, it's really difficult in the very beginning to narrow this down too much, because most buyers, when they're first starting out, don't necessarily know what they want. Oh, I love this neighborhood, but they don't necessarily want to limit it. A lot of times it's a school district, but again, that can change. So you want to make sure that you have that discussion with them and be a little broader maybe in the beginning and then narrow it down as you go. But again, that's the relationship with the buyer that you want to clarify. But understanding that is something that is going to be changeable as you move along. And you can change these as you go. Maybe start with a shorter term and then get a little bit more specific and a little bit bigger term. Again, it's up to you and your relationship, or you can just use a modification of terms as well. And you can use that for this form as well. So additional buyer preferences and priorities. There's a form, the BIP. I'm mixed on that one because we have a term, buyers are liars. They're not literally lying. It's just that they don't know. So what they say they want isn't necessarily what they want. So sometimes they say, I will only look at a house that doesn't have a pool. And then they fall in love with a house with a pool, right? We've all seen that. I only want a house that's 1 story. And then they end up buying a house that's 2 story. So sometimes that can kind of trap you into a search that isn't necessarily what that buyer really wants. So I would just talk to them about what they want. Maybe again, have that conversation with your broker about how they want to handle that. But this does create some potential for misunderstanding, or especially on the buyer side. Properties excluded from representation. I saw these 3 houses last week with this other guy that I ran into at an open house, and he showed me these 3 properties or attached list. Broker compensation. Guess what? The amount or rate of real estate commissions is not fixed by law. They are set by each broker individually and may be negotiable. I'm not sure if you guys knew that. The amount of compensation. This is where you talk about what you're representing and what you're going to be expecting as compensation. Remember, in the previous form with the RLA, it was only what the listing, the property owner was going to pay the listing agent, right? So this is only what this buyer's is going to pay you to represent him. So you want to make sure that you clarify in that conversation that you're having with this buyer, what exactly it is that he is agreeing to. Again, you're going to have that conversation with him, that the ability to negotiate that when you're in the negotiation for the price of that property. And as a seller, a lot of times what we've recommended is to talk with them about the net sheet, right? If they have a certain net that they want, it doesn't matter what the buyer is asking in terms of compensation, because you can negotiate that and you can adjust the price to end up with the same net. So again, you want to have that conversation with your buyer as well. Look, we can offer a slightly higher price to get that ability for that person to net what he wants, and then we get that included in the loan. And that price then includes all of the things that you wanted, including your lender buy down, maybe in a new rug, and also broker compensation. So let's talk about those and how we're going to work that into the purchase price. Just have an open conversation. Non-exclusive cancellation effective upon receipt or X days after receipt. We've heard of people that have gone into an open house, signed this form, and then walked out the door and canceled it. It still holds for that open house and for that address. So people are trying to be sneaky and get around things. Okay. They still owe a compensation should they purchase that property. And it's, if you have an exclusive agreement, it's cancellation effective 30 days after receipt. And by the way, if you fill this out and change this timeline, You can make it 10 days after receipt, 2 days, 1 day, whatever it is. Again, you want to have that conversation with them. Don't try and sneak this in here and change the timeline, but have this conversation with them and say, this will allow us the ability to, figure out what we're going to do about the properties that you've seen, etc. Time to deliver buyer personal financial information. So this protects you as an agent working with buyers. Oh, I'm approved up to $20 million. Okay, you have to give me that information within 5 days, 5 calendar days from the execution of this agreement, or they can attach it with this, right? So you want to make sure that when you're showing property that that buyer is qualified to purchase, but also has the ability to pay you. Here's where I just think this is an awkwardly phrased, and I believe this is going to be changing. There's been some suggestions. Buyer does not have sufficient funds to pay broker, or buyer intends to purchase with the following loan product, which does not allow buyer to pay compensation. That was really aimed at VA, but there are also some other lending vehicles that don't allow the payment of the buyer compensation. So you want to, again, have that conversation with your buyer. What loan are you using, and do they allow buyer compensation? The buyer doesn't have sufficient funds to pay broker. That one, a lot of buyers have balked at that because they say it makes them sound like they're poor, or that they're tin cup in hand trying to buy a house. It's some of them don't want to have that, don't want to pay the cash out of hand. They want to have it included in the loan because it makes it easier then for them to do repairs, etc. on the property. It's not a matter of not having the money. It's not wanting to utilize it for that. And so I think we are going to be changing that. But for now, you can have that conversation with them and say, they just simply mean that you don't want to pay that cash at close of escrow because you're going to utilize it for repairs or whatever it is. Doesn't mean you're poor. You automatically have the broker compensation advisory attached, and the compensation to broker, guess what? Not fixed by law. They are set by broker individually and may be negotiable. Not sure if you knew that, but that is a point. They include all compensation and fees to the broker, and they are fully negotiable. The broker right to compensation, it goes through what each of those items means. So broker involvement, I mentioned that. I do believe that's going to be changing for exclusive, but we will see what happens. Right now, broker involvement is for non-exclusive, and it means that the buyer physically entered the property, the broker showed the property to the buyer virtually, potentially, submitted a seller a signed written offer from the buyer to acquire, lease, exchange, etc. The broker performed a market analysis, or the property was introduced by buyer or broker to which broker acted on buyer's behalf. So basically, if you had involvement with this buyer and the property, these are the ways that you prove that. Continuing of right to compensation. Again, that was that section that I mentioned. How long does that hold? And what constitutes broker involvement? That's what this says right here. Broker involvement is these items here. And it is 4B4. Includes what broker involvement is. And it doesn't mean this is the only thing, but these items are included in broker involvement. If they have broker involvement, then they are entitled to compensation, provided it was clarified in the earlier format. And I mentioned you can have number of days after you've given them the name of the people, how long that holds for. Timing of compensation, and it's upon completion of any resulting transaction. Payments are through escrow. These forms will go to escrow. Escrow then will utilize these forms and the resulting agreement in the RPA to pay the agents who are due so what constitutes broker? So meaning the sales agent, not your actual broker. Yeah, no, your broker is not going to have to physically go out there and show your client the property. No, broker is interchangeable with brokerage. and you are the representative of that brokerage. So that means you as the agent in representation of the brokerage. And accounting for payments to broker if broker also represents seller. The other thing that's kind of been a sticking point, and we're out of time here, so I'm going to talk really fast, is that you cannot be paid more than what you agreed to in your BRBC. So if you have an X amount on your BRBC, but you're showing a property and the seller is offering Y amount, and it's more than what you would agree to with your buyer, you cannot accept that difference. The buyer probably can, but you cannot. You can rewrite or redo. I really don't see a buyer saying, sure, there's more money out there, but go ahead and take it. Because most people are you know, trying to find money in their couch to close houses nowadays. But you could have a written agreement that changed that agreement, but you cannot accept more than what your written agreement says. And I think you would have kind of a tough time explaining why you're trying to rewrite it for more at the. So it's better to have more and negotiate down than it is try to negotiate up, essentially. But again, have that discussion with your broker and understand how you're going to proceed with those agreements or not. The cancellation of the buyer representation agreement, as I mentioned, can be immediate, or unless you change that date and time and have it be a little bit longer. Agency relationships, you have to have that form. It will be included with every one of these. Possible agency with dual agency, that'll also be included. Advisory regarding buyer signing multiple buyer representation agreements. Guess what, Mr. Buyer? If you try to be cute and sign a bunch of these, you may end up owing more than one person. Commercial transactions are not exempt from the new law as of January 25. 1st of January in 2025, that law was just signed by Governor Newsom. And in January of 2025, this agreement will be required for commercial and all agents. So in the state of California, there's something like 440,000 agents, and only a little less than half of them are realtors. As of January 1st, this agreement will be upheld for all real estate agents, regardless of whether or not they are a member of NAR and CAR. And that will be commercial as well. Conflicts with other broker, it clarifies how they will be handled. Limitations on broker representation. All of these should be gone over with your buyer as you go through this form and explain to them. A lot of this, by the way, this clarifies what you do. The broker will assist buyer by doing this, this, this. You can also add what you specifically do and how you work with your buyers. And by the way, if you're a CRMLS member, CRMLS has a new program that goes into effect, I believe, next month, that literally will track your time and almost like an attorney does, by the hour, show what you do for both your listings and your buyers. It'll track your mileage, it'll track your time. They've done a study, and they asked the clients how much time they think their agent spends. And most of them say, oh, 20, 30 hours. And by the time we get done with a transaction, it's in the hundreds of hours, guys. So it behooves us to take the time to clarify what it is that we do and the amount of time that we spend doing it. We have for too long allowed outside sources, outside entities to clarify what it is that we do. A lot of those very fancy shows where everybody drives around and shows 3 houses and then they get a check and then they go back to the office and drink champagne and argue. That's how most people think we live. And that is our fault for not clarifying. So our professionalism and our duties that you guys are all here supporting are best represented by you presenting the actual truth of what it is that you do. and what your job is. So this form will help you do that. So the rest of this form goes through what their responsibilities are. And I strongly suggest that you guys read through this. This almost is verbatim what you can talk to them about, of course, in your own words, and include what you do specifically. But it talks about what our duties are and how it's important for them. A lot of people just think, well, I can negotiate a contract, and that's going to end up super great, and I'll get a better deal and I'll get a better price. The other half of this is that most transactions that are handled by a realtor are anywhere from 6 to, I believe it's 15% higher net price to the seller. And for buyers, the negotiation on things like, inspections and escrow and title and all of the things that they don't know they need to do are amazingly complicated. We all know because we work at this all day long. I know myself, I've been in the industry for over 30 years and I still learn new things all the time. I'm constantly going through all of the information. I grabbed this, hold on one second. Of course, it's not on my desk. This is the book that is the contracts. There you go. See that thing? It's huge. Of course, you can't see it because the format doesn't allow it. It's easily 2 inches thick. And this is the contracts that we have to deal with. And if buyers think that that's a simple process, then that is going to be a fun time. No, that book is available through CAR. If I'm a certified CAR forms instructor, and when you go through this, you can buy this form book, I think it's a couple $100, but it's put together by CAR. There we go. See how nice that is? It's all of the different forms and all of it's the sample forms book, and it has all of the forms, and it's got really good kind of explanations in here. It's got all the different forms so that you can go through it. It's got the names and the changes and all of the different details about all the different forms that we have to deal with. I've utilized that or some version of it for decades. And it just keeps getting bigger and bigger every time. And again, we're changing our forms again in December. Smaller tweaks, not as big as this last one. This last one, I'm not sure if you guys know, had 60, 68, 69 forms that were either changed or completely new in this last update. So, kudos to all of you that pay attention and are here. If an update is coming soon, should we wait until 2025 to order? Yeah, I don't know. I don't know that they would change, and they may just, I would maybe just get a copy of the things it's only a couple forms that are going to change, I think, and maybe include them. If you want something like that to utilize, I would start utilizing it. And then just as we get the new forms, maybe include them in the changes and then update next year when we have the big update. They don't do big updates unless something like this happens. Except every like 5 years, I believe it is, that they do a real major update. They do smaller updates in between as needed. So maybe, I don't know if they'll have it changed by then. They might. It's probably a good idea. I'd maybe call the hotline and ask them, when do you suggest, or do you suggest I wait? But yeah, it's a very useful resource. You can also go online and go on to car.org and I would strongly recommend you guys go through that and go through the legal updates. And then they have cheat sheets. They have all kinds of super helpful information in there. And I've always said that knowledge is power. And being able to speak coherently on a subject with your clients and also the agents on the other side and understand the nuances of the contract helps you negotiate, helps you keep deals together, and helps you get listings and work with buyers. People work with you because they know you, like you, and trust you. And that trust is based on knowledge. The reason they come to you is because you're the expert. So work on your expertise, right? Be the person who knows this stuff. It will only make you better at what you do. Okay, guys, we are way out of time. I always go over. I'm so sorry. And let's go out there and make some deals. And it's supposed to get hot this week. So take care. Bye, guys.